Java Jabber Live. I am your host, Rob Sassos. Java Jabber Live is where we talk about the news. It's not necessarily on the news, but newsworthy nonetheless. The news does have a real estate twist. Why? Because I am a real estate broker. I specialize in residential real estate and property management in the Central Florida area. Whether you're buying or selling or wanting to rent out your property, I am your dude, and this dude abides. You can contact me at rob@simplicityre.com or go to my website, simplicityre.com, anytime you freaking like. So let's talk about some news. And Java Jabber happens whenever I'm awake, the computer's behaving, and the coffee is ready. And whenever I get the chance to put a 25th hour in a 24-hour day. So, what do we got going on? Well, I'll tell you. Slow your roll, man. The problem with promises and handshakes, adding and modifying language to contracts, U.S. House focuses on institutional investors, and an early peek at the new Pups Pub. Oh, I can't wait for the first dog bite in that place. And then the Milk District has a car accident problem. All right, so problem with promises and handshakes. So here's some good information for you concerning mitigation, litigation, what's legal, etc. And there's also what's legal and what's enforceable. So a contract is offer, acceptance, consideration, meeting of the minds, and offer, acceptance, consideration, meeting of the minds. And it has to be on paper, by the way. Buyer and sellers can always agree to change contract terms. And when I say on paper, in Florida, to be enforceable, it needs to be in writing. Offer, acceptance, consideration, meeting of the minds. Buyer and seller can always agree to change a contract's term to get a transaction to closing. However, a handshake agreement generally won't change the existing contract until it's in writing and signed. Look at that there. Orlando, Florida, buyer and seller can always agree to change contract terms to get a transaction to closing. Just like we said, but that handshake may not do it, most likely won't do it. In the case of DK Arena Incorporated versus EB Acquisitions 1 LLC, a buyer and seller were at the end of the inspection period. According to the executed contract, if the buyer terminated during the inspection period, the buyer would be entitled to return of the deposit. There was an unresolved issue regarding the local approval of a project, so the seller verbally promised to extend the inspection period while both parties sought approval. After the approval didn't materialize, the buyer attempted to cancel the contract to get the deposit back. The buyer argued that the promise to extend the inspection period was clear and witnessed by multiple people. The seller, however, argued that the agreement to extend the inspection period was not enforceable due to Florida's statute of frauds. This centuries-old rule requires that contracts for purchase and sale of real property and certain other types of contracts be in writing and have proper signatures before they become enforceable. The Florida Supreme Court agreed with the seller's argument and held that promissory estoppel does not act as an exception to the statutes of frauds. Get everything in writing. Takeaways for buyers and sellers and realtors. When it comes to contracts for sale and purchase of real property, parties should always ensure their contracts and amendments are in writing and signed. And make sure that they're thorough. Don't be vague unless you're deliberately being vague for some reason. Be as thorough and descriptive as possible in terms of what you're agreeing to or make sure that it is if you're signing it. Parties shouldn't get ahead of themselves while negotiating contracts or amendments. Duh. We regularly hear from members who feel cheated when promising negotiations don't lead to a signed contract or amendment. There's not much to say beyond discussing the statute of frauds. Even if a buyer and seller verbally agree to every single point of negotiation and shake hands, if one of them won't sign a written document, there's not much the other side can do. Again, the word enforceable. The reason for refusing to sign is irrelevant. It doesn't matter if someone changed their mind about signing due to a family emergency or just realized they'd be financially better off if they didn't. Either way, promising negotiations aren't binding until the parties cross that finish line of signing the document. Parties should always orient themselves on the signed contract they have until they have fully executed amendments. If a party misses a deadline, as is the case above, the party should be penalized even though they were in the process of negotiating the amendment. As a final note, please remember that the statute of frauds only applies to specific types of contracts such as purchase and sale contracts, as are in real estate. Many common contracts are enforceable despite their verbal nature. That said, parties would be well advised to get most agreements in writing to avoid confusion and fights over how each side remembered specific terms. As it pertains to real estate purchase and sale, or sale and purchase, get it in writing. Make sure it's clear and understandable between all parties and get it in writing and executed. Can't say that enough. I've run into that multiple times with clients, with realtors, and just because you thought you had a good deal and you don't have it in writing, you don't have a deal at all. Remember, when you assume, you make an ass out of you and me. Adding and modifying language to contracts. Many times buyers and sellers want to add specific language to their contract that adds terms or changes to pre-printed language. While this may be doable sometimes, agents should use caution depending on the context of the changes. One of the most popular contracts Florida Realtors has available for members is the Florida Realtors Florida Bar As Is Residential Contract for Sale and Purchase, the FAR Bar As Is. While this contract contains many of the needed terms for a successful transaction, each transaction is unique. Sometimes buyers and sellers request to have certain things modified or flat out changed. For the purpose of this article, we're not going to buy this article, we will use the FAR Bar As Is language. While general basic changes to the contract are possible, sometimes the customer's request is more complex than it initially seems, and an agent should use caution before moving forward. A primary example, as the FAR Bar As Is contract name implies, the seller listed the property as is, which means the seller has no obligation to make repairs. However, many buyers want to request repairs from a seller after the inspection results come in during the inspection period, like 50% of the time, even though it's as is. While nothing prevents parties from renegotiating the terms of the existing contract, it is important to understand the nuances and risks in doing so in order to facilitate a smooth transaction. It's imperative to recognize this. There is no obligation on the seller's part to make any repairs, nor to even respond to a request for repairs. There is no obligation on the seller's part to make any repairs, nor to even respond to a request for repairs. As a buyer's agent, it's important to communicate this up front to buyers because you want a plan in place if the seller says no or simply doesn't respond. The buyer has a strong right of cancellation during the inspection period, but once that period expires, that's it. There may be other contingencies within the contract, but the time to cancel for any reason within the buyer's sole discretion is gone. Within the buyer's sole discretion. That doesn't mean it can't be canceled because you couldn't obtain financing, but any reason within the buyer's sole discretion is gone. I run into this a lot, at least the explanation of it. In some cases, a buyer hasn't heard back from the seller. The end of the inspection period is fast approaching and the buyer isn't sure what to do. In this case, the buyer must make a decision. Do I stay in the deal and potentially take the property as is without the requested repairs, or do I cancel before the inspection period ends? Assuming the seller does agree to a buyer's repair request, their agreement should be written into the contract under the additional terms or as an addendum to the contract. While it seems easy enough to jot something down, however, realtors should understand the importance of the language used in this repair agreement, and they should also understand the potential liability they're taking on if they take it upon themselves to draft this addendum. You need to be very careful with your words, those you are deleting, adding, or modifying, because then you become responsible for those words. Is the seller agreeing to fix an electrical problem? Great, but simply stating that the seller will do so is not adequately covering the parties. Far too often, calls to Florida Realtors Legal Hotline involve questions about the way in which the seller completed those agreed upon repairs. Most of the time in these cases, the language used in the repair addendum didn't address any repair standards. Say what would happen if the seller didn't make the repair at all, or outline what would happen if the seller's repair fell below the buyer's standards. So be specific as possible. Otherwise, it can become interpretable, if that is a word. The Florida Realtors contracts that obligate sellers to make repairs contains additional language regarding repair standards as well as when the repairs should be made. This language isn't in the FAR as-is contract. An addendum that involves many repairs of varying degrees likely should be drafted by an attorney to ensure appropriate language is used to protect the buyer and seller. Another example we hear about the legal hotline, buyers who want to add appraisal gap language. There is no appraisal to purchase price contingency in the body of a FAR as-is contract. Therefore, any language that intends to cover buyers' willingness to pay the difference between the purchase price and the appraisal is new language to this form contract and will be blunt. It isn't basic drafting. Depending on the buyer's exact intent regarding the language like this added to the contract, agents should advise their buyers to run any language by their attorney to ensure it covers the buyer's wants. I get it. Some realtors feel asking their customer to consult their own attorney is doing a disservice to the customer. Unfortunately, we get lots of calls from panicked agents, this is the legal hotline, who say their deal is blowing up because language added to the contract insufficiently addressed whatever the issues are. Recognize your limitations in assisting buyers or sellers. It's a good way to avoid problems later. The best answer when you don't know is I don't know, followed up with, however, I have an amazing recommendation that I might suggest to you so you can further pursue an answer to this situation. Have options available to them, but stay within your lane. You're not attorneys. Don't act like attorneys. Refer an attorney. There's plenty of amazing ones out there. You should develop relationships with them. And I'm talking to realtors. So that's what you get involved with. It can become a slippery slope when you start adding, subtracting, or modifying language within a contract. And agents always consult your brokers, buyers, and sellers. Make sure you are in good communication and understanding of what you're signing, adding, subtracting, etc. If you have any other questions, Rob at simplicityre.com. I am happy to assist. Go check out my website, simplicityre.com, as well if you want to know the home values in the area. You can go right to the top of the page or to the selling section. There's a home valuation calculator there. Just click on it, enter the address of the property. It'll ask you about 5 pull-down questions. Answer those. Hit enter. Yes, you do have to create a login and password. No one will hound you forever. It's just myself and my assistant Ava might say, hey, how are you? But you hit that enter button and boom, you will have an estimated value of the home that you're interested in along with comparable properties attached at simplicityre.com. If you want to know what a whole community is doing, like, I don't know, let's say you're interested in Bay Hill, where I'm a preferred real estate broker. Actually, I am the preferred real estate broker of Bay Hill Living. True story. I'm also a member of the Orlando Regional Realtors Association's Governmental Affairs Committee, Communications Committee, Podcast Subcommittee, and the local liaison for the city of Winter Park. I also specialize in downtown Orlando, Winter Park, Windermere, and of course, the aforementioned Bay Hill. So, U.S. House focuses on institutional investors. I love coffee. A committee looked at the impact on first-time homebuyers and minorities and the real estate industry if a high percentage of traditional family homes became rentals. Washington, Congress targets investors and asks the questions, where have all the houses gone? The pace of single-family rental home purchases by hedge funds backed by investors has risen in recent years, according to the data submitted by the companies to the U.S. House Financial Services Committee. During a June 28th committee hearing on the own-to-rent industry, witnesses called for expanded protections for renters, more public housing, limits to local zoning rules that prevent new housing from being built, and other federal laws to help bridge generational wealth gaps. In 2011, no single investors owned over 1,000 U.S. homes. However, the 5 biggest investors owned a combined 280,637 as of October 2021, adding 76,325 homes to their portfolio between March 2018 and October 2021. Q3 2021 institutional investor homes, Invitation Homes, 85,512 homes, Progress Residential, 71,930, American Homes for Rent, 56,077 homes, First Key Homes, 35,899, Amherst Residential, 33,219 homes. These homes would likely have been bought by first-time home buyers. Low to middle income buyers are both, said U.S. Rep. Al Green, Democrat from Texas, chair of the Financial Services Subcommittee and Oversight and Investigations. Meanwhile, a memo submitted to the committee indicated that home builders may turn to institutional investors to buy more of their product as more buyers get priced out of the market. According to the witness testimony before the committee, institutional investors target minority communities and prevent them from building generational wealth through home ownership. According to Green noted, lower income buyers are losing out to institutional investors that buy homes with cash. This all has the troubling effect of displacing residents of color and leading to gentrification of these communities. He also called the companies very poor landlords. This is true. I've experienced one of these. American Homes for Rent was horrible, and I got no problem saying it. Citing steep rent hikes and evictions, including during the COVID-19 pandemic. Jenny Schultz, a senior fellow at nonpartisan Brookings Institute, said, "It's a long-term problem caused fundamentally by the fact that we're not building enough homes." So there you go. Now you have those whole build-to-rent communities, which are building single-family home communities that are solely for rent. Don't know how I feel about those. Think that's a waste of money on your part. But want to talk about it? Sure. Rob at simplicityre.com or ping me if you see me. Get an early peek at new Pups Pub before it opens. I don't know why I am so fascinated by this. Downtown sports bar that has indoor-outdoor grass throughout, and you can bring your dogs to the bar. And then it has a neon sign that says "Bitches Running Wild." And looks like the waitresses wear those shirts too. Isn't that just sweet and sexist and all of that? So Pups Pub, a popular membership-only dog park bar out of Tampa, will open a new Orlando location. Actually, it already opened July 1st. It is right across the street from St. James Catholic Cathedral. We got an early look at the new facility. If you want to go check it out, go to bungalower.com. I don't get anything from them. There's just a cool website. They're local, hyper-local website. Highly recommend it to go check it out, see what's going on. Pups Pub features a full liquor bar, 22 televisions, a fenced-in dog run area, air conditioning, and fans to keep things cool, and Caesar Milan-approved AstroTurf that's easy to clean. It's still AstroTurf. What's it matter if Caesar approved it? Memberships start at $15 for a day pass, so a $15 cover charge, $30 for a month, or an annual package of $299. Learn more about the various membership options on the website. A 50% off deal valid through the opening. Pups Pub. You can go to @PupsPub if you want to call them out on, what is that, IG? Anyways, I'm just waiting for the first dog bite. That's all I got to say about that. The Milk District has a car accident problem. I'm surprised it hasn't had it sooner. Those buildings are so close to the freaking road. And you're serving alcohol, and it's an aerial road. What's the worst that could happen? Well, let me tell you. For anyone paying attention, there's been a lot of car accidents happening in the Milk District, a few of them involving cars that have hopped the curb and went flying into nearby storefronts. There have been 36 documented incidents involving car collisions and hit and runs along the Robinson Street corridor in the past 2 years alone, according to the data shared by the Orlando Police Department. The majority of these incidents took place just east of Bumby Avenue, where the storefronts are particularly close to the right-of-way, with a number of them having been struck in the past year, including Stasios Italian Deli and the Milk District Spot. Milk District Main Street Director, interesting, Zach Alfson, shared that he's working with the city of Orlando to try and find a solution, saying, "We haven't had any fatalities yet, but the city has been very responsive and is working as a go-between with the FDOT to come up with a solution." Why? Because it's a state road, so the FDOT owns it. Robinson Street, like I said, is state-owned, so it's got to be approved through the FDOT. The Florida Department of Transportation will be holding a public meeting on Robinson Street Improvement Project on Wednesday, July 27th at 5:30 p.m. at the First Unitarian Church of Orlando to share progress and updates. So, let's see. So watch yourself when you're drinking down in the Milk District, and yeah. That's pretty much it. There was a couple articles about some real estate, but it was just buying and selling apartment complexes. Wasn't going to talk about that. More wanted to know what you guys thought about Java Jabber and the topics that we have. If you'd like, please leave your comments. If you want to hear more about educational things like contracts and what to look for and things like that, or if you want to know more about what's happening in the area, And of course, as always, both options is always an option as well. But if you have any questions, let me know. By the way, if you're doing property management and you're interested in our amazing property management services, say you heard me on Java Jabber and I'll take 2% off your monthly property management fee. Reasonable customary is 10%, so you do the math. But that is it for a Tuesday. I hope you enjoyed it. If you did, please like and share. It means a lot to me. I am a local business owner, small business owner, and all the assistance I get is tremendously appreciated. Plus, go check out my reviews on my website, or go to Zillow, or go to Google, and see I do a darn good job. And so does my team. I got a really amazing team. So like I said, buying or selling real estate, property management, try Simplicity, a real estate brokerage company, as your solution. We'll be back Thursday. Until then, you all have an amazing week. And if you have any questions, let me know. Otherwise, we will see you on Thursday. Talk to you later. Have a good one.